Hello, everybody. Ava is tucked under the desk on top of my feet still. She's not impressed with the 4th of July. Yeah. And we're back. Hello, T-Rex. Hello, Nana Laura. I told y'all I'd be back. Hey, so, I don't know when this was delivered. The label, it's a bit faded. I don't know if y'all can see how faded that is. It actually looked darker on screen there. It was found out in the yard in the front, kind of in the bushes area. It's got all kinds of like grass all over it and stuff, so I don't know who sent it yet, but we're gonna find out what it is. It definitely got rained on. Oh my goodness! Oh my gosh. It's kitty wands. Look at Earl's like, yes, I know what it is. Who's this from? Hope they enjoy, from Nicole. Thank you so much. Oh my gosh. I am so grateful. 12 pieces interactive kitten toys, retractable indoor cat wand toys with replacement teasers, rainbow ribbon, and make exercise, and then it's cut off. Oh my gosh. Cat feather toys, sunshine wands. I love it. Thank you so much, Nicole. Oh my goodness. Earl's like waiting. He's dying. He's like, I can't believe you just found the package. I want to play. Oh my gosh. Earl is going to chew on those cables. I'm going to have to hide them when they're not in use. He does that. He loves to do that. Oh my gosh. It's got replacement wands. These are great. I can choose which feathers to put on them and when. Ooh. This reminds me of color guards. Oh my gosh. This is going to be so fun. Thank you so much, Nicole. Oh, and there's Billy. He's like, my turn, my turn. Ha ha. This is great. Oh my goodness. And then there's all of these cute feather toys. And you can't forget the worms. These are Earl's favorite. Absolute favorite. Oh, I love this one. Oh, and a pink worm. I got it in my head one time that I was going to make a homemade kitty toy like these, but I used wooden beads because I'm a dummy, and it made it so heavy the cats are scared of it. I learned my lesson that day. Hello, Mortimer Duke. Good to see you. I wasn't answering you for a minute because I wanted you to think it wasn't on. Hello, Hello, Spider-Man. Ow. I just whacked my thumb on the desk. I cannot multitask. Yes, happy Independence Day. Happy 4th of July. Yes. Me too. All right, guys. We have got a lot of fun tonight. Not that we didn't have fun earlier. One thing that I didn't tell you earlier, there may be another one. Oh, whoopsies. You just stole that right out of my hand. Tough guy. Yeah, so the Moorish American sovereign citizen that I played earlier, I chose her because I had multiple hearings of hers. But as I was editing, I did happen to catch a few subtle clues that Lucretia might be one. Might. No promises, no guarantees, but she sure sounds a little bit like it. So I have a feeling that we're going to get to see a double dose of Moorish subsidiary. I know. Anytime people are being dumb, it's entertaining, and they never fail at failing. Oh my goodness. All right, let me see here. Do. But first, we're going to spend some time in Judge Caretti's courtroom. Keep up. That's all I'm going to say is keep up.
Judge, the court can call People versus Lewis. Time and date set for pretrial. Motion.
Anthony Sorrentino on behalf of the people.
For the record, Judge, my name is Paul Stocky, and I represent Durante Lewis, who is also present via Zoom.
Okay, go ahead.
I mean, council has a motion up. We've kind of been over it. Realistically, there's no offer. If he wants to proceed to trial, if the facts come out and the court allows, I'd be adding felony firearm. It's already undercharged as is. So,
Your Honor,
when at the last pretrial, we talked about a deviation in this case. Was that ever submitted, Mr. Sack?
it was, I think, and it was denied. Hold
Really?
on.
That's what we were waiting for, is the result of the deviation. I did not know it was denied.
It was denied, Mr. Sorrentino?
Yes, Judge. He pulled a gun out on a guy who was there. Is this the car one where he went to get the
No, I
car?
don't think so.
Yeah, no, it is.
Oh, yeah, maybe it is.
The tow truck, and he pulled a gun. Like I said, it's probably, well, not probably. It's assault with a dangerous weapon, which would also, if that was the case, include a felony firearm. It's undercharged. The deviation's denied, and that's where we're at.
And then, Judge, we do have that motion pending as well.
What's what counts is the motion directed to?
The
Probably
motion,
one.
I mean, just count one, right?
yeah, it's directed to the carrying concealed weapon.
All right, Diane,
Yes, Judge.
send Stocky, Sorrentino, myself to a breakout room.
Okay, Judge. Yes, Judge.
Diane,
Yes, Judge.
send Stocky and Lewis to a breakout room.
Okay.
Judge, the court can recall People versus Lewis. Date and time set for pretrial. Motion.
Anthony Sorrentino on behalf of the people.
Again, Your Honor, my name is Paul Stocky, and I represent Mr. Lewis, who's also present today via Zoom.
All right, and yes, we have to do a breakout room. Diane,
No, we don't, Judge. It's my understanding Mr. Stocky is going to move to withdraw. The defendant has rejected the offer, or the discussion has been not fruitful, and that's where we're at. Just trying to save you some time.
all right,
Your
well,
Honor.
thank you. I appreciate that. But you know what? It's set for a motion.
Yes, Judge.
Well, I guess I'll still do the breakout room. Diane,
Yes, Judge.
Stocky, Sorrentino, myself to a breakout room.
Okay.
Mr. Lewis, just stay on Zoom, please. Thank you.
Stocky's not back yet.
There he is.
All right, so Mr. Stocky, you just made a motion to withdraw. Is that right?
That's correct, Your Honor.
All right, I'm going to grant your motion to withdraw, re-refer it to the defender for appointment of counsel. Give us a new date, Madam Clerk, please.
Judge, we can set this for August 1st at 9:30. Mr. Lewis, did you get that date? Mr. Lewis.
Just call our next case, Francesca.
Sorry about that. I didn't hear you. Said what again?
August 1st at 9:30.
All right. Thank you.
Thank you. Judge, the court can call People versus Gettler, time and date set for pretrial.
Anthony Sorrentino appearing on behalf of the people.
Good morning, Your Honor. Noel Jerry, Assistant Public Defender, on behalf of Mr. Gettler. He is present via Zoom. Robert, unmute yourself.
Go ahead.
All right,
Judge,
I'm here, Your Honor.
So at this time, defendant pleads guilty to added count 2, attempt eavesdropping. That makes it a 1-year misdemeanor. Dismiss count 1, dismiss the HAB. We have a sentence agreement to 2 years probation. I think counsel indicated his client's getting mental health treatment, so continue the mental health treatment. No contact with the complaining victim, Rosalie Audia, or her family directly or through the use of an agent.
Judge, that is correct. The only slight modification is that it would be with any minor family of hers. There are a number of adult stepchildren, I guess you could call them, which I don't think would be covered by any no contact order.
All right, swear the defendant.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sir, state your name.
Robert Allen Gettler.
You understand, sir, that do you understand all the rights your attorney has explained to you in connection with this plea?
Yes, I do, Your Honor.
It's my understanding, sir, that you wish to plead guilty to the charge of attempt eavesdropping. Is that right?
Yes, Your Honor.
Do you understand the maximum penalty you may receive is up to 1 year in jail?
Yes, Your Honor.
Do you understand the plea bargain agreement, sir?
Yes, yes, Your Honor.
You're pleading guilty to that charge, correct, sir?
Yes, Your Honor.
In return, the prosecutor is willing to dismiss count 1 and the habitual notice, correct?
Yes, Your Honor.
Is that the complete plea bargain agreement, sir?
Yes, Your Honor. I believe it is, yes.
Is everything you expect from the plea bargain agreement set forth on the record?
Yes, Your Honor.
Are you accepting the plea bargain agreement of your own free will and choice?
Yes, Your Honor.
Have there been any promises or threats to get you to plead guilty today?
No, Your Honor.
Do you understand you will not at a later date be able to claim there were promises or threats that caused you to plead guilty today? Do you understand that, sir?
Looks like he's cut off, sir.
Excuse me? Yeah, yes, Your Honor.
All right. Have there been any such promises or threats, Mr. Sorrentino?
No, Judge.
I have not, Your Honor.
Counsel,
No, Your Honor.
please tell me, sir, what you did on February 18th, 2025 in the city of Warren leads you to believe you're guilty of that offense.
Your Honor, may I voir dire?
Yes.
Thank you, Your Honor. Mr. Gettler, on February 18th of 2025, did you attempt to place an eavesdropping device in the bedroom of Rosalie Audia?
Yes, I did.
Okay. And at that time, did you have Ms. Audia's permission to do such a thing?
No.
Okay. And was that in the city of Warren, County of Macomb?
Yes, it was.
All right. I believe that covers it, Your Honor.
It does,
Yes.
Judge. Satisfied.
Court's complied with court rule, Mr. and Jerry.
You have, Your Honor.
All right, sir, to the charge of attempt eavesdropping, how do you plead?
Guilty.
Court will accept the plea of guilty. Anything you want to say in his behalf before I impose sentence, counsel?
Yes, Your Honor. Mr. Beekler and Ms. Audia, they have kind of a long relationship. They were married twice, divorced twice. Ms. Audia was living in they were living in the same house. Mr. Beekler has mental health issues, and he has, since this case has been initiated, he has re-engaged with his mental health treatment. He's getting it. He's doing everything right.
I have never understood the concept of marrying your ex-spouse. If it didn't work out the first time, I mean, you already know what you're getting into. What makes you think it's going to be better the second time around?
He is going to treatment. He has complied with the exclusion zone and the tether. And I know that I received some notices of that he had entered the zone, but I can explain those in a moment. But with regards to this itself, even before he was arraigned in district court, he moved out of the house. He's moved in. He's in his brother's basement. He's attempting to do what work he can. He is staying away from his Audia. He understands that she doesn't want to see him. He shouldn't see her. And that's where that is. So, and I think that probation is the appropriate sentence. And I would ask that if he goes 1 year without any issues, that he be allowed to come back to court and ask off. But he understands that the court is watching him, and that if he sets a foot wrong, he knows exactly where he is likely to end up. And so I would ask that the court put him on probation, allow him to demonstrate to the court that he's not going to see these issues. There's not going to be any more issues here. And,
All right, Mr. Beekler, anything you want to say?
No, I just want to say that, Your Honor, it was if I keep it, because I have an ADHD really bad. So also, I didn't have any I didn't mean any ill harm by the actions that I committed. I was a little paranoid. I felt that she was trying it. The house is mostly mine. And I felt that she was plotting against me to try and get me out of there.
All right, sir. Mr. Aaron Gary, you said you were going to address the tether violations.
yes, Your Honor. So one of them indicates that he went there to collect his belongings, some of his belongings. That was after Judge Chimura signed an order saying that he could go there with a civil standby. I was present. He was there with 3 police officers. He conducted himself correctly in all respects. With regards to the other one, Your Honor gave him permission to enter the zone for work purposes, which is what he did. And with regards to the other one, he was in there for a minute and didn't stop. So I think he just brushed the edge of it. But for all that, Your Honor,
that's fine. That's fine. I'll accept that explanation, Mr.
Thank you,
Jerry. It is a sense of the court you be placed on probation for a period of 2 years. I'll order that you not use drugs or alcohol. Seek and maintain employment of at least 30 hours per week. Complete the Class A Training Center program on impulse control. You're to pay a $50 state cost, $75 crime victims rights assessment, supervision fee of $30 per month, court costs of $750. Sir, you're entitled as a matter of constitutional right to file an application for leave to appeal your conviction and sentence. If you're financially unable to provide counsel to perfect such appeal, this court will appoint counsel for you. Request for assistance of counsel must be made within 6 months. Counsel, you're to get assigned advice rights to the court.
you'll have it within the hour, sir. One last thing, sir. Could you let him off the tether? It's costing him money that he doesn't have. He's living in his brother's basement and spends most of his time in the garage, as you can see. It's a
Well, that's
financial-
an odd question, Mr. Aaron Jerry, because that was a condition of bond. Obviously, he's automatically off the tether today.
Oh, okay. Yes. Thank you, sir.
And Judge, one thing, you didn't mention it, but no contact, obviously.
Yes, no contact and complete his mental health treatment.
Yes, Your Honor. Thank you.
And then, Your Honor, if I may just add to the order, he has jail credit of 17 days. Just, I don't know if you'd order 17 days credit for 17 days.
Yes, I'll do that as well.
Thank you.
Thank you, Your Honor. Robert, you're all set.
All right, thank you.
Judge, the court can call People versus Pointer, date and time set for sentencing review.
Anthony Sorrentino on behalf of the people.
Good morning, Judge Caretti. Mark Haddad on behalf of Ms. Pointer.
All right, give me a moment. We were reviewing restitution, I believe.
Yes, Your Honor,
Judge,
the issue,
it's
the
like
issue is
200
restitution.
bucks. So they're very close. I have no problem with an adjournment, but I'm not going to agree to the reduction unless it's paid in full.
Your Honor, the restitution $1,750 was joint and several among two co-defendants. I'm unable to determine what, if anything, the co-defendant has paid, but Ms. Pointer applied.
Well, Madam
her
Clerk should
bond.
be able to do that. Francesca, can you tell?
Sure, Judge. What is the co-defendant's last name?
Kelly Smith, Kellie Smith. And Judge, I said at the time of both pleas, I don't care how it gets paid as long as it's paid in full. I'm not, dealing with these people suing each other, but the restitution, regardless of who pays it, needs to be paid in full.
That was our agreement, Your Honor. Thank you.
So I'm not trying to be
No, I understand. I remember.
difficult.
Francesca, anything yet?
Judge, I'm looking. She's got more than one case.
Yeah, it's the larceny case. Here.
Looks like one case she's up for sentencing, so she hasn't been sentenced on file ending in 3092 FH. And then her other file ending in 262 FH. Let me see.
Well, so last time we were here, he was $125 short. Is that right?
I
Judge-
agree with that, Your Honor.
Judge, this is the case that we contacted judicial aid about. It was $125 because Mr. Haddad brought to the court's attention that $75 was applied incorrectly by judicial aid. That information was unfortunately incorrect. That $75 was added court cost. Defendant posted cash bond 10%, so the court keeps that $75 as the 10% bond fee.
So it is still 200.
So it is still 200.
Okay.
Mr. Sorrentino, can you verify, is it an MDOP 1,000 to 20,000 on Kelly Smith?
No, it should have been a larceny. Hold on, I can pull her up though. Let's see.
Well, here, I mean, it doesn't matter unless she's paid it.
It's 3092 is the case.
3092 costs.
Oh, it
Looks
looks like she's set for
pending
sentence.
sentencing. Miss Kelly Smith is pending sentencing on August 5th, so she has not paid that restitution because that has yet to be ordered.
All right, how much time does he need to do that? And he also needs to do his Class A, or I'm going to violate him. So, Ms. Haddad, how much time should we
Your
adjourn
Honor,
this for? We'll
would-
give him a chance to pay.
I would ask that we come back after the co-defendant has been sentenced. The co-defendant has a bond. I'm sure that's going to be applied. And then the restitution will be fully paid.
Well, that's something you should check into, Mr. Haddad, because at the next court date, I'm not going to give him another adjournment. If it's unpaid, then the felony will be abstracted. So,
understood.
Give us a
Oh boy. So that person could be on the hook for paying the whole thing. And it doesn't matter whether the co-defendants pay into it or not. That restitution is getting paid one way or another.
date after that sentence date,
August
Madam
12th.
Clerk.
August 12th at 9:30, Judge.
Thank you.
Thank you. Judge, the court can call People versus Woods, date and time set for a probation violation hearing and a probation violation arraignment on amended warrant. Mr. Woods has failed to appear or check in with his court.
Anthony Sorrentino on behalf of the people.
Daniel Garrett for defendant. That's correct, Your Honor. Both phone numbers that I have for him are inoperative, and I have no explanation for his failure to appear. I'll note for the record that the request for the warrant is for the same behavior.
So is attempt breaking and entering a charge that we have to wait 48 hours on Mr. Sorrentino or Mr. Rapsky?
I don't think so, but I'm not positive, Judge. B&E.
Mr. Rabsky, do you know?
No, Your Honor, I'm not sure.
It's a 10-year, is it B&E with intent? Yeah, I would say, my guess would be no, just based, oh, it's attempt? Huh.
Judge, it looks like
All right,
Mr.
I
Woods,
don't
Judge, it looks like Mr. Woods is just now entering our waiting room.
All right.
Great.
I just let him in. Still connecting.
In that
Judge, Mr.
respect,
Woods is
All
now.
right, Mr. Woods, turn on your camera and unmute yourself. This matter was set for 9:30, sir. It's now 10 o'clock. Why weren't you on Zoom?
My phone is currently broke. I just used my brother's phone. I had to come over my brother's house to use his phone.
All right, Mr. Garrett, have you apprised him of the nature of the new warrant?
I have not, Your Honor. This is the first time I've even seen him.
All right, give us a new date, Madam Clerk.
Judge, we can set this for August 7th at 9:30.
And I'm going to read them on the new warrant anyway. So what is the new warrant, Mr. Rabsky? Would you read the allegations, please?
Yes, I will. Warrant dated June 13th, 25. Violation of condition 1. Offender failed to report monthly as instructed. It is believed the offender is a threat to himself and the community based on his substance abuse history. Violation of condition 8.1. The offender has paid $0 towards his restitution balance of $3,000. Violation of condition 8.18. The offender has paid $0 towards his state cost, balance of $68. Violation of condition 8.2, paid $0 towards his crime victim rights fund, balance of $130. Violation of condition 8.14, $0 towards his court cost balance of $900. And violation of condition 9.31, failed to attend Class A impulse control class within 30 days as instructed.
All right, the court will enter a plea of not guilty. We'll set this matter for hearing on all the warrants on.
Judge, I believe counsel made a request to me via chat. He would like it after August 16th. So
yes,
that would
please.
Why is that, Mr. Garrett?
I'm going to be on vacation for 3 weeks, for the last week in July and the first 2 weeks in August.
So you're taking a shorter vacation than usual this year?
No, my name's not
Only
Chris
3
Fisher,
weeks,
Your Honor.
All right, go ahead, give him a new date.
August 21st at 9:30. And Judge, as to bond, are we continuing the 5,000
Yes,
person?
I'll continue his bond, but make sure you're on Zoom at 9:30, Mr. Woods, on that date. Do you understand that?
Yes, sir.
Mr.
Okay.
Woods, I need contact. I need to talk to you. You call my office, please. Give me a number.
All right, Mr. Stocky, are you on?
Well, Your Honor, if I may, for Mr. Woods, recommend that he report to the probation office before the end of the day today.
Yes, he's ordered to do that as a condition of his bond, Mr. Garrett.
Thank you, Your Honor.
Make sure he understands that.
Thank you.
Judge, can we get a phone number for Mr. Woods due to counsel not having one?
Sure. What's
Mr.
your
Woods,
phone
what's your
number,
phone
Mr. Woods?
My phone is currently broke. I don't know my brother's phone number by heart.
All right, he doesn't have one. Next case.
Judge, the court can call People versus Toutant, date and time set for pretrial, a probation violation hearing, and a probation violation arraignment on an amended warrant dated today. Judge, that was not signed until 9:30 this morning. I emailed it to you. I can read it if you would like.
Okay. Appearances?
Anthony Sorrentino on behalf of the people.
Good morning, Your Honor. Jason Malkowitz on behalf of Mr. Toutant.
Okay, have you apprised your client of the nature of the new warrant, Mr. Malkowitz?
Judge, I have not had a chance to look at it yet, but I'd wait formal
All right,
reading.
read it, please, Francesca. Thank you.
Contrary to condition 9.81, zero tolerance, defendant submitted to a drug test at Metro Testing Services on 6/11 of 25. On 6/25 of 25, the probation department received information that the defendant tested positive for THC with a level of 983.9 milligrams milliliters. Cut off is 15. Defendant does not have a medical marijuana card. Defendant submitted to a drug testing services on 6/4 of 25. On 6/17 of 25, probation received the defendant test on 6/4 returned for a positive test for methamphetamines and amphetamines. Defendant also tested positive for THC. Defendant submitted to a drug test on 6/3 of 25, on 6/20 of 25. The test from 6/3 returned for a positive for THC and methamphetamines. Defendant failed to report to testing on 6/26 and 7/1 of 25.
What's his bond on all the files, Madam Clerk?
Let me check, Judge.
Okay.
Judge, can we do a
So
breakout
Mr.
room?
Malkowitz, he's continually failed to test or test positive. I don't think he should be out on bond, but I'll let you address that.
Judge, I know when we were here last time, you increased his bond, and he did post that. Unfortunately, he still has not been testing negative as I would wish, Judge. I'm asking the courts, I did file a deviation. I was just advised this morning by Mr. Sorrentino that appears my deviation was denied. I need to have an opportunity to speak with Mr. Toutant in regards to another possible option of resolving this case.
Judge, could we do a breakout room? I mean, I'm looking at
Diane.
Okay.
Yes, Judge.
Breakout room, Malkowitz, Sorrentino, and myself.
Okay.
Judge, I have that bond amount if you're
All
ready.
right, what is it?
5,000 cash assurity, 10% with GPS tether with all county
On which case?
on both. So he has posted that bond on both. It is furnished by Lisa's Fast Bill Bonds.
And is he on tether at present, Mr. Malkowitz?
Judge, I think they joined the breakout room.
I am, Your Honor.
Everyone just stay on Zoom. We'll be right back.
You could pick a date, Madam Clerk. We're gonna set this for pretrial in motion.
Judge, we can set this for August 7th at 9:30.
Can it be in person? Because I have a feeling that motion is gonna be to revoke bond.
Do you think the turnover on the transcript will be that quick, Mr. Malkowitz, considering where this file's coming from? St. Clair Shores. I don't know the turnover there.
I think it should be pretty quick, but hope if we need a little longer, perhaps.
Okay. Sounds good.
Judge, as far as bond due to the amended warrant,
I mean, with his behavior, I feel like his bond should be amended, but.
Well, and I did just want to add, the last time we were here on the 5th, Judge had said if he misses another test, he's going to revoke his bond. And I mean, he's missed several.
guys, give me 1 second because Judge cannot hear us. I'm sorry, Judge. No, we cannot hear you.
Oh.
Sorry, guys. Judge's audio just went out, so he did not hear any of that. He's going to log off and come right back in 2 seconds.
Francesca?
We can hear you, Judge.
All right. So we need a new date and for both files and a motion hearing.
Judge, that would be August 7th at 9:30. And Judge,
All right.
as to bond due to the amended warrant.
Yes, bond will be the same, but I think I'm going to change the condition. What's his testing regimen now? How frequent? Do you know, Mr. Malkowitz?
Judge, it's random, I believe, 2 times a week.
How many?
Twice a week.
All right, so I'm going to change his testing regimen to once a week, and I'm going to make it with the TAP facility, not Metro.
As if it matters.
Your next missed drug test, Mr. Toutant, I'm going to immediately revoke your bond. Do you understand that?
Yes, Your Honor.
Your Honor, I did just want to add, I know you just made your order. Both May 6th at the hearing and then June 5th, you had also ordered if he missed another test that you would revoke his bond. Now we have about a dozen since that time.
I was hoping no one would remind me of that, Mr. Rabsky. He's ignoring my orders. I should revoke his bond now, but I'm giving him one last chance against my better judgment. But thank you for that information.
Okay.
Thank you, Your Honor.
Lucky day.
Thank you.
Call the first case, Francesca, please.
Judge, the first case is a pickup for our court, People versus Kimbo, time and date set for probation violation and arraignment.
Anthony Sorrentino on behalf of people.
Timothy Young on behalf of Mr. Kimball for purposes of arraignment, Your Honor.
Hold on. Diane,
Yes, Judge.
I only have 4 pickups, not Kimball. Why is that?
I sent Kimball last. I sent it to
Again,
you at
I don't
9:40.
have it.
I emailed it at 9:40.
It just came through. All right. Counsel, have you apprised your client of the nature of the warrant?
I have, Your Honor. We'd waive formal reading. My client will stand mute. We ask court to enter a not guilty plea on his behalf.
All right, court will enter a not guilty plea. That's not coming up. Well, here, it just did come up. Hold on a moment. All right, the court will enter plea not guilty. We'll set the matter for hearing on.
July 15th at 9:30 via Zoom.
All right, your client, can he afford to retain counsel?
Your Honor, he's requesting court-appointed counsel.
Refer to defender for appointment of counsel. You can be heard as to bond counsel.
Thank you, Your Honor. My client is working. He's also helping with his mother. He is in therapy to deal with these issues. So we'd be asking for a personal bond to allow him to be out to continue working, to continue going to therapy.
Judge,
Mr. Sorrentino.
Did you look at the allegations? I mean, they're
Yes, I
blatant.
did. I looked at the allegation and he's on probation for
The same-
accosting children for immoral purposes.
I mean, I think there needs to be a large cash bond, to be perfectly honest. He is just disregarding the court's orders, what he's supposed to be doing. To me, this behavior shows that he's clearly a danger to society. I mean, I can't believe the behavior, to be honest.
All right, Ms. Sorrentino, I agree with you. I'm going to set his bond at 25,000 cash surety or 10%. I'll make a condition of that bond. He be hooked up on the GPS tether with the EMS company prior to his release from the jail.
Thank you, Your Honor.
Mr. Kimball, you may exit and grab the deputy.
There you go. Hi, Judge.
Good afternoon, everyone. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. All right, so let's see if we have enough people here to make out a group. We have first up Credit Acceptance Corporation versus Enrique Leon.
Plaintiff's ready. My bar number 35222. I am the moving party. Plaintiff's motion to set aside an installment payment order.
You're on Credit Acceptance Corp. That's not. I'm sorry. I don't have a set aside. This is for a motion for summary disposition. Are you on Credit
Okay, I'm sorry. Which one did you call, Judge?
Credit Acceptance Corporation?
And Isis Leon or Enquina?
Yes.
Got it.
Leon. Yes.
All right, wrong case. I have some others. So
Okay.
I'm here for the plaintiff.
All right, you're still here for the plaintiff. Okay, good. All right, Ms. Enriqueta Leon, please state your name.
Enriqueta Leon.
Thank you. All right, we're here for a motion for summary disposition and a pretrial today. Ms. Leon, I think last time you were here, you indicated you didn't have the motion,
Yes, correct.
and now you have received it.
Yes,
Have you had a chance to review it?
yes.
Do you want an opportunity to speak with Mr. Rosen to try to see if you can work out anything before he argues his motion?
Yeah,
Yes, yes, Your Honor.
if defendant wants to speak, I'll be happy to do that in a breakout room, Judge.
All right, thank you. We'll put you in a breakout room. And I'll pass this matter. I'm sorry.
All right.
Okay. All right. One moment, we're gonna rename Miss Leon so that we know who she is. We have 2 iPhones with no names. All right, you'll go into the breakout room at this time. All right, was there some problem in the breakout room? Miss Leon was not able to stay in to have a conversation, or what happened?
I was the only one there.
Okay.
Your Honor, my phone shut off due to the temperature. And so I had to wait for a minute. I'm at work and it came out out here, and so my phone cut off, but I can go.
Ms. Leon, you have a terrible connection, so I think it's more than just the phone cutting off. Are you moving or are you stabilized in your vehicle?
I'm stabilized in my vehicle.
Okay. You keep cutting in and out, so he's gonna have a hard time trying to talk to you today. But I'll give you give you both a chance to see if you can make that work. I'm gonna put you back in the breakout rooms.
All right. Thank you, Judge.
Thank you, Your Honor.
You're welcome. Make sure your video stays off. That might help with the process, Miss Leon, okay?
Okay.
All right, thank you. All right, we're gonna go back to credit, yes, she is. Credit Acceptance Corporation versus Enriqueta Leon, case number 25C0973. You're still muted, Mr. Rosen.
Let me take it from the top. I am attorney Richard Grusin, and my bar number is 35222 on behalf of the plaintiff.
Thank you. Miss Leon, if you could unmute, please. Can you state your name? Thank you.
Enriqueta Leon?
Thank you. All right, the parties had an opportunity to go into a breakout room. Did we have any success in the breakout room?
Well, I think so, Judge. Richard Grusin, the plaintiff, while the case was in recess in the breakout room, the parties discussed the parameters of this lawsuit and the motion today. Judge, I can tell you that I have a consent judgment with the defendant, whereby consent judgment will enter in the amount of the complaint, which was based on the automobile note deficiency balance of $14,694.20. I explained to Ms. Leon that there are taxable costs. I explained that it costs $160 to file the lawsuit to have the summons issued. And then it costs $43.40 to have that summons served upon Ms. Leon to bring us up to the present moment. And there was a $20 motion fee concurrent with the filing of plaintiff's motion for judgment. Total cost of $223.40. I explained to Ms. Leon that the state of Michigan grants me, as the plaintiff's attorney, a statutory attorney fee of $20. The total consent judgment will enter, Your Honor, in the amount of $14,937.60. More importantly, the parties have agreed that concurrent with the entry of the consent judgment, that there will be an installment payment order entered in the amount of $80 monthly, beginning July 16, 2025. And Judge, before I rest, as I explained to Ms. Leon, I would ask defendant's permission to sign the proposed consent judgment so that I can file that with the court before the end of today. With this, I rest.
Thank you. Ms. Leon, is that a correct statement of the agreement that with cost and the original request for damages, the total is $14,937.60?
Correct, Your Honor.
And you've agreed to pay that installments of $80 per month?
Yes, Your Honor.
All right. And is your motion for summary disposition going to be withdrawn?
Well, it's funny you should say that, Judge, because I think that would probably protect the record that way. Yes.
And then the other thing I'm going to ask is, do you have her email address in order to send her a copy of this when you submit it to the court?
Okay. Yeah, Judge, I'm sorry. I keep forgetting your court is not yet electronic filing court, but I'll be happy to. Oh, you know what? I do have Ms. Leon's email. Is that not true, Ms. Leon? Because you've been in contact with my office, right?
We learned earlier what happens if you don't have the correct email address.
Do you know if he has your email address?
Yes, yes.
Okay. So we want to make sure that he does have it so that he can send you a copy of this document. When he submits it to the court, I want you to be CC'd on it. I like for everybody to know what's coming in at the same time in case something's awry. Okay?
Yes, Your Honor.
So he'll submit that and email you at the same time. And once he does, then I will sign it.
Thank you.
Thank you, and you're both all set.
Okay, thank you.
Thank you, Judge. I do have two more matters on your docket for the 215 docket.
Thank you. All right, next, the court will call the case of Westlake Services LLC versus Sharice Patterson, case number 25C0988.
Good afternoon, Your Honor. Eduardo Polaris, P63559 on behalf of plaintiff.
Good afternoon. Ms. Patterson, please state your name.
Sharice
All right, thank you. All right, we're here for a pre-trial today in this particular matter. Have the parties had an opportunity to talk to see if there's any potential for resolution?
Judge, this is actually a second pretrial. We spoke at the last one. This matter is pretty heavily disputed by the defendant. So I'm not sure if we'll be able to reach any resolution.
Okay.
Hello? I'm right here.
Who? Please stop talking, ma'am. I'm talking to someone else on a different case.
Oh, I'm sorry. I'm sorry,
Okay.
Your Honor.
That's okay.
I'll be happy to talk to the defendant if she wants to, but I'm not sure we're going to get anywhere.
All right, thank you.
Maybe it'd be best if I do talk to her, Judge, if you want to put us in a breakout room, if she's okay with that.
Give me one moment. All right, so this matter is over a Dodge 2005 15 Journey?
Yes.
Okay.
Correct.
Is this a deficiency case in which the vehicle was sold and there's a deficiency?
That is correct, Your Honor.
All right, thank you. I just wanted to make sure I understood what was going on. I'll put you through in a breakout room.
Thank you.
Court will recall the matter of Westlake Services LLC doing business as Westlake Financial Services versus Sharice Patterson, case number 25C0988.
Again, for the record, Eduardo Polaris, P63559 on behalf of the plaintiff. Ms. Patterson, can you state your name too?
Sharice Patterson.
Thank you. All right, the parties had an opportunity to talk. This is a pretrial. Where are we with today, please?
Judge, we have reached a resolution. I'd like to place the terms of that on the record, if I may.
You may proceed.
Your Honor, we have agreed that the defendant will settle this matter for payments totaling $7,175.16. She will pay that in 36 monthly installments of $199.31, beginning August 15th, 2025. We will execute a conditional dismissal, Your Honor, wherein we agree that this matter will be dismissed without prejudice. As long as the defendant continues to maintain those payments as agreed, it will stay dismissed. If the defendant fails to do so, plaintiff will submit affidavit of noncompliance to the court, give the defendants 2 weeks notice, and the matter will be reinstated for judgment to be entered for the full original balance minus any payments made pursuant to the agreement I have put on the record today.
Thank you. Ms. Patterson, did you just hear the agreement that's been placed on the record? First of all, you agreed to settle the balance on this for $7,175.16.
Yes.
And you're going to pay that in installments of $199.31 beginning on August 15th on a monthly basis?
Yes, Your Honor.
And then if you pay it off, it's all good and dandy. This case will be dismissed and it will not be on your record. You failed to pay it. And they're going to come back and bring me this document called a non-compliance, and it'll give you a 2 weeks notice, but they're going to be asking that the case be reinstated, a judgment be entered against you, and then they're going to do that judgment for the full balance, and they'll begin collections all over again. So it's really important that you pay that $199.31 on a monthly basis timely, okay?
Yes, ma'am.
That's your agreement?
Yes, it is.
All right, great. I will sign that when it comes in. And congratulations on working out a good deal for yourself.
Thank you.
You're going to submit that
Thank you, Your
today, Mr. Polaris?
No, I'm going to have to email a copy to the defendant. She said she'll email it back, but she needs to go to work to be able to get access to a scanner. So Ms. Patterson, help me if I'm wrong. I would say maybe by next week we can get this all wrapped up.
Yes, that sounds great.
It'll be fine. This is what I'm going to do. I'm going to set it over for September 4th, 2025 at 3:00 p.m. for entry of order. That order is in here. It will not be on the docket. So that's just my tickler date to make sure that I don't lose track of the case and get in trouble by my bosses over at Scale. I have two, my recorder over here and the Supreme Court. Those are my two bosses. Have a good day.
You too. Thank you.
You're welcome. Bye.
Bye-bye.
All right, the court will call the case of LVNV Funding LLC versus Lucretia Carr. Case
Good. Oh, sorry.
5C87.
Hello.
Good afternoon, Your Honor. Alexander Popov appearing on behalf of plaintiff.
Thank you. Ms. Carr, please state your name for the record.
Lucretia Michonne Carr.
All right, thank you. All right, we're on, here on a motion to set aside the default judgment in this particular case. Ms. Carr, you filed this motion. There are two things that you have to be able to prove to the court. One is that there was good cause for the fact that you didn't show up to court, and two, that you have a meritorious defense, a valid defense to the claim. So both of those things have to be proven.
Yes. My first initial reason, I didn't know exactly how a summon works. And I had a few things going on at that time. I had an eviction I was in court for at the time, and I just didn't know what a summons was. I had never had one before. I thought that I was waiting on a court date to come to me. I didn't know that I had to go to the court and file an answer to the situation, and till I called and I spoke with someone, and then I figured out what my next steps were to discuss the situation. And then naturally, when I look at the information of the summons, the even paperwork that I received, I did not see. I'm sorry, I got some notes I wrote down. I was looking for a purchase agreement, legal authority. I didn't see my name, my account number, any of the things that are the bill of sales.
All of these arguments sound so familiar. It's like deja vu.
And then I had wanted to do more research because I had a few different people contacted me about this same account. I even have an email from a different company that claims that they have this same account. So I don't even know what's actually happening at this time with this account.
Thank you, Counselor.
Thank you, Judge. Going by her motion, she stated that she had good cause because she didn't understand what the summons meant. The summons clearly directs the defendant to respond within 21 days. Therefore, we would argue that she doesn't have any good cause. If we go to the meritorious defense argument, in her motion, she said there was no meeting of the minds because multiple creditors contacted her. She hasn't provided any evidence of that, and if so, it's immaterial because there was mutual assent between the two parties, and the statements reflect that with payments and purchases. Therefore, we would argue that there's no meritorious defense either, but she hasn't provided good cause or a meritorious defense.
What does assent mean, so that she can understand that big word you just used? She's not an attorney.
Sorry, that we both came to an agreement.
And you're saying that was evidence because she spent using the account?
Yeah, so we gave her credit to use the account, and she utilized the account by making payments and purchases.
Oh. And case law says?
The case law I can give you right now.
But the case law says if you do that, then that is considered mutual assent, correct?
Correct.
Did I had the account with you?
You have an account with his client, ma'am?
And his client is?
LVNV funding.
And see, I don't have an account with LVN funding. You're saying that I had an account with LVN funding. I never opened an account with them. I never signed any paperwork with LVN funding.
Yeah. So my client purchased the debt from the original creditor, which was Credit One Bank.
That's not what they said. They did not purchase it from the original creditor. I have some paperwork here that says they purchased it from somebody else.
So there is a chain of title. But we own LVNV. My client owns the debt.
But you said that I had an account with LBN, and no, I didn't. And they didn't buy it directly from that company.
It doesn't
Yeah.
matter whether whether they bought it from that company or not. They attached the bill of sale to this, and an assignment of the account is attached to the actual summons that you were served with.
And there's no purchase agreement.
Ma'am, you don't get to fight that once there's an assignment. That's not for you to fight. That's between him and whoever. If they have an issue as to whether or not it's a proper purchase, you don't get to make that. That's not your argument. Make.
It's not my argument to make that if there's a purchase agreement with my signature and stuff on there. I mean, not the purchase agreement. I'm sorry. I'm looking for,
Well, first of all, before we even get to that issue, I was just trying to address it because you brought it up. The first issue, ma'am, is that you can't come to court and say that I didn't know I was supposed to answer a summons. The summons tells you right at the bottom that you have 21 days after receiving the summons and a copy of the complaint to file a written answer with the court and serve a copy of the other on the other party or take lawful action within 28 days if you were served by mail or you were served out of the state of Michigan. It tells you right at the bottom what you're supposed to do.
unfortunately, I didn't understand what the paperwork was, so I didn't even process what that was saying to me. I didn't even know that's what it was saying.
Well,
I had never had a summons to court before.
Well, the more unfortunate
And
piece.
then I Googled summons and it said that I would be sent something in the mail
Ms. Carr,
according to a court date.
Ms. Carr, I know you hear me talking to you.
I apologize. I'm not trying to irritate you. I was just telling you what from my understanding.
Again.
I'm not trying to.
Stop speaking over me.
When I'm speaking, you wasn't speaking. I'm sorry. I wasn't trying to speak over you. I'm just trying to understand what was going on. And I just didn't understand
You
it.
started talking. That's what's going on. I was explaining. I was actually reading when you started talking, ma'am. So please don't do that. Okay?
Okay.
So as I was reading to you, this is what is required by this piece of paper. Whether you have an understanding of that or not, doesn't change the fact that you were served with the document that says that. The law says that you are required to read it and to understand it or to get legal assistance. You don't get to come to court and say, I didn't understand it. That's not the way this works. Now, what is it that you want to say?
I don't know. I mean, I know what it says, but I just didn't understand it. So, I mean, if I didn't understand it, then I called to get some advice to understand what was being said and what's handed and what was given. I just didn't understand what the paperwork said. I mean, I don't know. I know what the law says. I know what the paper says. But when I read it, it didn't process to me what I had to do next. So I called and I spoke to a clerk and they directed me to that area. And I said, oh, this is what it says. And then I didn't know. I just didn't understand it. I know the law wants me to. I know I may be irritating you, but I just didn't understand what I was reading. And I had wanted to apologize and see if I can have the opportunity to look over the evidence and see what I was being, sued for and who was suing me. That's all. I just didn't know. I apologize. I have the opportunity.
I'm not. All right. Are you done yet, ma'am?
Yes, I am.
All right. I'm not asking you to apologize for not understanding. That's not what I'm upset about. I'm upset because when I was talking, you kept cutting me off. That is irritating.
Yes, ma'am.
As to the second part, because there are two prongs. Even if I were to give you the benefit of the doubt, then you have to get to the second prong of this. is whether you have meritorious defense. And the things you're talking about are not a meritorious defense to this. There is a proper bill of sale that they have that allows them to actually sue you. So the second question is, what are you trying to tell me about your defense? Because there's no purchase agreement. That's not what this type of case is. So what are you trying to tell me about that?
I was thinking, I didn't mean purchase agreement. I was looking for more information for the company to have because I'm not a lawyer, I do not know all of the information. I had a short time to research a few things. I would need more time to research a few more things of what's all needed to be provided to say that they own the debt and that I am responsible for the debt. That's all. I just needed more time to look over it. My opinion, I didn't see any of my account numbers in any of the information that was given over. I didn't see any dates on any of the paperwork when the signatures was put on there. I didn't see any of that.
All right. So when a action is filed in court, ma'am, first things first, no one puts full account numbers on it. They're supposed to be blocked out. That's considered personal identifying information. So you would not receive it with that on there. Secondly, the bill of sale is attached showing that they now own the debt and they are able to sue you for this particular action. Before I make a ruling on your motion, do you want a chance? And this is over a credit card debt with Credit One Bank. So it's a very cool thing. You can talk to them and see if you want to resolve this before I make my ruling. Maybe they'll work out something with you, or you can choose to not talk to them and I can make my ruling. Do you want to try to talk to them and see if there's something you can work out?
Sure. I don't mind talking to them.
Okay. We'll see if there's something the two of you can work out. I'll put you in a breakout room first and then I'll call the case, okay?
Okay.
Thank you. All right, the court will recall the case of LVNV Funding LLC versus Lucretia Carr, case number 25C-1087. Mr. Popoff, please state your appearance again.
Yep. Good afternoon, Your Honor. Alexander Popov appearing on behalf of plaintiff.
All right. Miss Carr, can you please state your name again?
Lucretia Carr.
All right. Where are we with this matter, Mr. Popoff?
Judge, we were unable to reach a resolution.
All right. So, having said that, then I will have to make a ruling on the order regarding the motion to set aside the default. As the court has indicated earlier, there are two standards that must be met. One is that there's a good cause, meaning a good reason to find that the defendant did not show the court or did not answer the complaint. As I indicated earlier, the fact that the defendant didn't understand the document is not actually a good reason to not set this aside. In addition to that, I haven't heard anything that would satisfy a meritorious defense. The motion to set aside is denied. I will sign an order to that effect. We're all set here on that particular case. Have a good day.
You too, Judge. Thank you.
What's your name, sir, with the iPhone there with God Don't Play About Me shirt on?
Byron Taylor.
The court will call the case of Credit Acceptance Corporation versus Carlos Walker, 17C-2620.
Plaintiff's ready, Judge.
You can go ahead and place your appearance on, please.
Good afternoon.
Mr.
Can you hear me?
I can't hear you, Mr. Walker. One moment, please.
Okay.
Mr.
Okay.
Rosen, please place your appearance on regarding this one.
Thank you, Judge. May it please the court. I am Attorney Richard Bruson. I'm one of the attorneys for record for the plaintiff, and my bar number is 35222.
Thank you. All right, now, Mr. Walker, please state your name.
Carlos Walker.
All right. This is your motion to set aside the order for installment payments, Mr. Rusin?
That is correct, Judge.
At the time you filed, you indicated that Mr. Walker was $1,790 in arrears?
That is correct, Judge. Since that time, he's paid a little bit. He's paid $350 that I've received in hand since I filed that petition, just so that the record is perfected, Judge.
Mr. Walker, what happened with your installment payment, sir?
I was off. I had a little suspension at work with no pay. And now that I'm back, that's when I start paying the proceedings.
I see. Mr. Wilson, do you want to talk to him to ensure that maybe he can continue with his payment plan?
Well, I think we need to go in the breakout room, Judge, and let me just tell you why. And I'm just being matter of fact. I have reviewed, Your Honor, the rest of actions. Mr. Walker in 2020 had an installment payment order that was in and then set aside on December 20th, I believe, 2020. Then he made another installment payment petition, and that was set aside subsequently. Let's see here. So we got one payment order that was set aside. Then we came back to another payment order in 2023. And here we are in 2025 with payment order again in arrears. So I'm mentioning this, Your Honor, before I go into the breakout room, because you know, these sorts of orders have to be fair and balanced. I'm all in favor of installment payment orders, but if I have a multiple default rate, I've got to go forward with a garnishment because the balance keeps going up with the 13% interest rate. And Mr. Walker needs to understand that the court issues an order, it has to be paid every month. If it's not, you can't get the best of both worlds by having a protective order and then not paying on it. So that being said, Judge, I'll be happy to go in the breakout room.
All right, Mr. Walker, you understand what he's saying, correct?
Yes, ma'am. But like I said, if I wasn't getting any payment from work, there was no way. And then once I did start getting payments, I still had other bills that I had to proceed as well. And I'm trying to show faith within the last 2.5, 3 weeks. I've given $350 of my the 1,700 rearage.
It doesn't matter. It's just like with diversion. If you don't comply with a diversion agreement, then it goes back to the original charge. Same thing with this. If you don't pay on the agreement, then it's just done.
Right. But what he's saying is if you set up payment plans and you cannot meet those obligations, then what happens is you can't be under the protection of the court anymore. That they're going to furnish. One moment, please.
Testing. I apologize, Your Honor. We're back up and running on the record.
Okay. The system stopped working. So what he's saying is that if you can't continue to make the payments for whatever the reason is, then they have to proceed with other methods of collecting. So having said that and fully explained to you what he's saying, and hopefully a little bit more layman's terms, you can go in the breakout room and talk, okay?
Okay, thank you.
Thank you.
Thanks, Judge.
Pass this. You're welcome. Thank you. All right, the 14B District Court is back in session. The court will recall the case of Credit Acceptance Corporation versus Carlos Walker, 17C2620.
Thank you, Judge. May it please the court. I am Attorney Richard Grusin, and my bar number is 35222, and I am the plaintiff's attorney.
Please state your name again, Mr. Walker.
Carlos Walker.
All right, thank you. Mr. Rusin, where are we with this, please?
Well, I've had a long talk with Mr. Walker as to where we've gone in this case since judgment was entered in 2017. And Judge, the long and the short of the matter is that I noticed that this is the second time now that I've had to file, my office has had to file a motion. I'm going to give Mr. Walker one more chance in the sense that he has made very good intentions to keep on the installment payment that was entered. And, you know, so we have a $150 payment coming around in July that's due. So, Judge, for the record today, I will withdraw my motion, or you can just simply deny it, so that Mr. Walker can continue on his $150 a month plan. That's the long and the short of it. And with that, I rest.
All right, I'm gonna do it as a withdrawal, and I'm writing a note that you withdrew it to give him another opportunity.
Yes.
And Mr. Walker, I'm gonna tell you, sir, that I know that I have given you an opportunity. I did that back in September of 24.
Yes.
Try to do this, and then at one time, yes, so this is your second opportunity. That's your 2 bites.
Yes, sir. Yes, ma'am.
He's not giving you another opportunity, and neither am I. So you need to figure it out. If something happens and you have another financial hardship, you need to borrow so you can pay this, because you won't be on a payment plan anymore. They're going to be to garnish your wages when you do start working again. So please keep that in mind, okay?
Yes, ma'am.
It's funny you should say that, Judge. For me and Mr. Walker, we talk baseball, so so we're arriving at the same happy place that you are on the record now. So that I want this to have a happy ending with Mr. Walker. I gave him some ideas, and I hope that's useful. So today the record is perfected.
You're welcome. Thank you, everybody. Have a good day.
Thank you,
Judge. Good luck, Mr.
Right.
Walker.
Thank you.
What's your name, sir, with the iPhone there with God Don't Play About Me shirt on?
Byron Taylor. Can you hear me good?
Yes, I can.
Yeah, okay. I'm at work, so I'll just make sure.
All right, thank you. The court will call we can't call that one yet because the attorney on that is in the breakout room with the other person. I'll call it as soon as they come back, Mr. Taylor. Okay?
Okay.
All right. The court will call the matter of LVNV Funding LLC versus Byron Taylor.
It's not the same attorney, Your Honor.
It's not?
Pop off this one, I cleared that up, and it's actually Olivier.
Oh,
The
Olivier?
who is not signed in yet.
Oh, the attorney on this is not signed in? Okay. All right, Mr. Taylor, apparently the attorney that filed or is supposed to be appearing on this motion has not signed in. Do you want to state your name for the record?
Yes, Byron Taylor.
All right, this matter was set for 2:15. It is now 2:39. Plaintiff counsel has failed to appear. The motion is dismissed.
Okay.
You're all set, sir. I'm dismissing their motion. They didn't show up.
Okay. All right. Thank you.
Thank you. Mr. Taylor, you need to sign out, sir.
I got one more, Your Honor.
I don't think so.
Oh, let's look. Can I give you the number that I think I'm on your record for?
Yes.
This is with case number 23C4196. LVNV Funding versus Byron Taylor, who's there.
Sorry.
Oops.
I didn't realize you were the attorney on that one. It says Olivier is the attorney.
Oh, that's my partner, but that's okay. You know what, Judge? How about this? I will refile the motion. You know what? It's nobody's perfect. Like they used to tell me at Catholic school. So let's just refile, unless you want to just sua sponte issue a new hearing date, and we can move forward that way. Things happen.
I think that's what I'll do. It's oh wait, did they come and get the file already?
Yeah.
All right.
Would you like me to go grab it, Your Honor?
Yeah, I'll grab it and give you a new hearing date. Yeah, because I didn't realize that it was you.
Things happen, Judge. You've had a long day, and it's hot. I can see it in your face, actually.
It is been a long day. It's not that hot in here, but it has been a long day.
It has been a long day. I'm sure they haven't put the coffee bar yet over in the district court. You know, they have a coffee bar over in Flint, in the circuit court. Yeah.
Really?
Yeah. I said, what a great idea. Why isn't all the courts have that?
Have a coffee bar. We don't even have a courtroom right now. So
Oh, mercy.
our court is under renovation. It'll be back in action well, we probably won't move back in until January.
Oh my. Well, it would be nice. Well, look at when you were last January, this is the weather you probably dreamed about, like everybody else. I'm just saying.
That is all true.
All right.
All right. I did not deny it. So what I ended up doing was just dismissing it. So it wasn't denied. What I did was said it was dismissed because I didn't think anybody was here.
Got it.
Plaintiff counsel was in breakout room. And what I'm gonna do is I'll set the hearing. Dismissal retracted.
Yeah, because as you know, the court under MCR 2.612 can correct clerical errors sua sponte. I think that's A1. So
well, it's not actually sua sponte. What it is right now is, well, let me call it so we can make a clear record. The court will recall the case of LVNV Funding LLC versus Byron Taylor, case number 23C4196.
Judge, may it please court, Richard Bruce, on behalf of the plaintiff, and I am also representing LVNV Funding, in this case as petitioner.
Thank you. In this particular case, the court called it earlier when you were in a breakout room, Mr. Rusin, and unfortunately, I was not aware that you were the attorney on it. It said Lynn Olivier, and you said it's your partner. And so at that time, I was not aware of that. And I dismissed it and allowed Mr. Taylor to leave. He was here present. I'm going to retract my dismissal of that, and I'm going to set it for a new hearing date. Unfortunately, I do have to put it out for a time frame here. I can put it as early as August 14th or August 28th. Which one works best for you?
Oh, the 14th is fine, Judge. Will that be at 2:15 again?
Let me find out from my boss.
All right.
Oh, all right. We'll set it at the 2:15 time again, okay?
Oh man, all that happy cheesing that guy did, and you're gonna take it away from him. Oh, you guys are so mean.
Can I leave you laughing when I go?
Of course, I love that.
It's funny that you say I thought Miss Olivia was appearing because I get a lot of mail in my office, so I had somebody on my door, but after about 15 years, I got tired of looking at it. The letter was actually addressed to, and it was for an installment payment, right? Rusin, somebody and somebody. And I told Lynn Olivia, I said,
Oh, wait, you broke up. Oh, wait, slow down. I couldn't hear anything you were saying, and I really
the letter was addressed to my firm, but it was addressed to Rusin, somebody and somebody.
Okay.
So I told my partner, Lynn Olivia, you really need to be in the office more, so. All right, so I left you laugh when I go. Have a great weekend, Judge. We'll catch you on the next call.
Thank you. See you soon. Bye-bye. Somebody and somebody.
Attorney Fanta?
Yes, this is Andrew Fanta.
Okay, thank you. Now calling 25C2120G. This is Auto One LLC versus Samantha Weston, also known as Samantha Weston?
No, Samantha.
Okay, so then we misspelled it somewhere. Just a second. Okay, excuse me. So let's try that again. Samantha Weston, also known as Samantha Nickel. So can I have your appearance, please?
She is not with me. I told her it was a pretrial and it would be unnecessary for her to be here. I asked Auto One for an adjournment and never heard from them, so I had to cancel plans for a trip to Canada where I would not be in phone or laptop range, and accordingly, my request to this honorable court is for an adjournment on Tuesday, September 11th.
Okay, so first, Attorney Fanta, can you put your appearance on for me?
Yes, I'm so sorry. I apologize. Attorney Andrew Fanta, P 29540, representing the defendant Samantha Weston.
Well, he's in awful good spirits for someone who had to cancel a trip to Canada for this hearing. Oh man. Yeah. He's in the wrong business. No, I'm just kidding. I have never heard a lawyer do that though. He's real old school.
Thank you.
Okay. Thank you. So this was set for a first pretrial today, as you noted, and it had been initially filed as a small claims case. We did receive your demand and order for removal, and it was duly removed. And we have your answer here. Since that time, I'm not seeing anything in the file that we received from the plaintiff. So I am happy to adjourn it out. Do you have any motions?
Well, Your Honor, what I'm hoping to do is if that September 11th date, which is a Thursday at 2:00 works for the court's calendar, that will give me time to talk with somebody at Auto One to see if we can't resolve this matter. That's what I'm looking for. And it would give me enough elbow room that if I'm unable to resolve the matter, to file motions or to seek to have an evidentiary hearing or a deposition, whatever would be called for. Thank you.
Thank you. Are you requesting that we open discovery at this point?
Yeah, I would say if you'd adjourn the pretrial to September 11th and use the same date, pardon me, Your Honor, use the same date for discovery. So that gives us a bit of time for me to do discovery if necessary.
Okay, thank you. So then at this time, per your request, I will adjourn this matter out to September 11th, 2025. That will be at 2 in the afternoon over Zoom in front of Judge Washington. And discovery will be permitted up until that point. You will receive a pretrial order in the mail.
Well, thank you so much, Your Honor. And for the record, I wish you a wonderful 4th of July weekend. I had the pleasure today of having some 4th of July cookies that I had made special by Dom's Bakery, and I dropped off one box of a dozen or so to the post office on Adams Street and took the second box into the clerk's office at City Hall in Ypsilanti. And it just gives me pleasure to recognize folks that are in our lives and perform a service for us many times, way too often, a thankless service. And so that put a smile on some postal employees' faces and a big smile on the clerk's office at City Hall. I wish you a good weekend, Your Honor. Thank you.
Thank you. You as well.
Bye-bye.
Bye.
Mr. Hoffmeister, let's see.
I cannot start my video because you have disabled it, Your Honor, which I find extremely offensive.
Let's get it reactivated. I was trying to reduce the number of boxes on my screen.
An opinion.
All right. State of Kansas versus James Parks Jr. These are case numbers MGI 24 CR 395 and MGI 25 CR 215. Mr. Parks appears by Zoom with, but separate from counsel, Mr. Hoffmeister, stayed by Mr. Gayoso. The 24 case is on for diversion status, and the 25 is for a formal first appearance. Looks like that was reviewed, that was accomplished on June 17 before Judge Biossard. How do you want to proceed today, Mr. Hoffmeister?
Well, Judge, I've had a recent meeting with Mr. Parks, and he's not completed the diversion application in the 24 case because of the new case. And I'm needing to have some further conversations with Mr. Galloso after reviewing the new case, which I have not had a chance to review discovery because I've not been formally appointed yet. What I'd really like to do is set this for settlement conference, at least the new case, and both cases on the afternoon in Coffeyville at a later date. And then I believe that allows me time to get acclimated to the new case and have some conversations with my client and Mr. Galloso about a resolution that can resolve both cases now that there are two rather than one.
All right, your thoughts, Mr. Galloso?
I'm fine with setting it for a settlement conference on July 31st at 1 o'clock, Your Honor.
All right.
And the problem is, Judge, on the 31st, I am going to be out of the office. So what I would ask is either we set it out 8 weeks or we, for a one-time only thing, have it on July 29th in Independence in the afternoon for settlement conference.
I don't have an issue with the August 28th date since Mr. Parks is not in custody, if that would work with Mr. Hoffmeister in the court.
Are you available August 28 at 1 o'clock, Mr. Hoffmeister?
I am.
Then that's what we'll do. So, Mr. Parks, your next court date is going to be Thursday, August 28 at 1 o'clock in person in Coffeyville for a settlement conference. We are going to go ahead and appoint, hang on one second. We're going to go ahead and appoint Mr. Hoffmeister to represent you in the newest case, 25 CR 215. And you had a question, sir?
Yes. Okay. So I talked to my lawyer and I also talked to bond supervision. I've got a job opportunity for Keystone Service Incorporated. It's out of Glenpool, Oklahoma. My bond supervision was okay with it as long as you granted me it. I will be working Monday through Friday. The only problem is, I will be working in Kansas, Oklahoma, and possibly the Texas line. I talked to the boss, Lino, and he said that anytime I need to come in for bond supervision, I could. The times that I'm working, I would call in, and he would clarify that I was working. Bond supervision was okay with this. I just needed to get the agreement from you that it was all right with you. It would also keep me out of this town, out of trouble. It's a rogue working crew. It'd be really, really good for me.
All right, Mr. Galloso, any objection on behalf of the state?
Your Honor, I know he's had prior issues with failure to report on bond supervision, and I see that Ms. Brock filed an affidavit showing that he had 5 failures to report, which that is concerning for the state.
Let me get that pulled up.
Was that a newly filed affidavit?
I'm just showing that it was entered on
December
June 18th, or what my notes show, but I'm not certain when the affidavit would be.
'Cause I know there were some previous issues that I believe were addressed. I'm just curious if these are new or continued issues after the initial issues were addressed by the court.
It looks like it was.
This affidavit was filed June 18, which should have been after his last court date on May 9. So these appear to be new issues.
And it looks like he also tested positive for methamphetamine as well. And he was arrested.
I did not. By who?
Mr. Parks, just don't say anything right now.
Sorry.
And it looks like the allegation would be for testing positive and then the new contact or the new arrest.
Which is the newest case, 25 CR 215.
That is correct, Your Honor.
Is Miss Brock on?
It's just myself, Your Honor.
Ms. Shake, was it Mr. Parks advised that I don't know if it was you or Miss Brock. Basically, court services advised him that your office was agreeable to him traveling out of state for work purposes if it was okay by the court. Is that accurate?
That is accurate, Your Honor.
Okay. All right, Mr. Parks, I'm going to authorize you to leave the state of Kansas for work purposes only. I guess the caveat is you do need to return to court August 28th at 1 o'clock. You need to continue reporting on bond supervision. If I get any affidavit from court services that you've missed even one bond supervision reporting,
Yes.
then your permission is going to be revoked and you'll be required to return to the state of Kansas if you're out of Kansas working.
Yes, sir. Thank you very much.
You've been less than compliant with bond supervision, but I'm going to give you a chance to turn things around, but it'll be a short leash, so to speak.
Yes, sir.
So take advantage of opportunities so you can become gainfully employed. Anything
Thank you very
further on Mr. Parks' case today?
Nothing from the state, Your Honor.
Nothing further from defense.
All right. Thank you. We'll see you August 28th at 1 o'clock in Cockville, Mr. Parks.
Thank you very much.
Judge is giving him just enough leash to do something that would get me demonetized instantly. Oh gosh, what a great 4th of July, you guys. This was amazing. I am so grateful for everybody that came and spent it with me. Yeah, you know what I'm saying. You know what I'm saying. And Ava's still at my feet. I swear, she's part camel. Unless I am busy, and don't want to take her out, then she's got to go. But I cannot get her to go outside. I just can't. She will not leave my feet. Thank you so much. Yeah, she's a spoiled little baby and she knows it. Thank you so much, Sandy Hurd. I love you. I love you all. We tuckered Earl out. Thank you, Nicole. Those toys, oh my goodness. He was hunting for the toys. Every time I would wrap one up, put it away, he'd come up here and try digging around to see where I put them. I put one in a drawer, the rainbow one, and he actually pulled it out through the back end of the drawer. Like he reached his little paw into the desk drawers because they're the cloth ones. Yeah. He broke in and stole it. Clever little fella. That would be super appreciated. Thank you. Thank you, Nana Laura. Good night. Happy Independence Day, everyone. Be safe, be well, sleep sweet, and much love.